Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about severing counts on multi-count indictments. Cases that should have gone to the Supreme Court of Canada, but didn't. Olivier Charrière was running a grain storage and trading business, and in the course of running that business, ultimately he was investigated for and charged with a number of offenses relating to fraud and theft. Mr. Charrière was charged on an indictment that listed many of the offenses that he'd committed together in the same count, and he applied to the court to try and sever the counts into individual cases. And this case raised an important question about whether it's appropriate and an appropriate exercise of Crown discretion to group together multiple incidents in the same count on an information or an indictment. After all, a person may have a defense to an incident that took place in January 2018, but no defense to an incident that took place in February 2018. They may wish to plead guilty to one of them and advance the other one to trial. But by grouping together multiple incidents into the same count on an information, a person is effectively prevented from fully being able to realize those things without making additional applications to the court. Those additional applications are also inconsistent with principles that the Supreme Court of Canada has expressed, like things like trying to conserve trial time by creating more simple informations rather than complicating trial time by making it necessary for people to bring a number of applications. Mr. Charrière argued effectively that grouping together multiple counts was contrary to the principles of natural justice. And we look at the interplay of natural justice, charter principles, and the function that the courts perform and the function that the courts need to perform in controlling its process using very broad counts on an information or an indictment that include multiple different incidents and offenses, makes it much more difficult for people also to understand what they're being charged with. One of the reasons for an information or an indictment is to ensure that a person has sufficient particularization of what they're being charged with so that they know what the case is that they have to meet. Disclosure, of course, accomplishes that to some extent, but the information itself has to be sufficiently particular for the person to understand what they're being charged with, and a broad-based information doesn't fulfill that function. So there were a lot of good reasons for this. And the use of broad informations that cover multiple incidents has been increasing because it makes it a lot easier for Crown to lay charges in circumstances where otherwise they would have to pick and choose which ones were actually stronger and which ones were less strong, and lump everything together into a single count. It can also make it easier, to some extent, for accused individuals when coming to court, because rather than pleading to 15 separate incidents, all of which attract a mandatory minimum penalty, a single incident would only attract one mandatory minimum penalty. There are benefits and there are downsides, but the Supreme Court of Canada should have weighed in on these benefits, these downsides, and the role that they play in all of the laudable goals we have in our justice system, ensuring that there's natural justice, compliance with the Charter, simplifying trials, and allowing the court the ability to control its processes. And unfortunately, they didn't take the opportunity. Hopefully another case comes before the court where the appropriateness of multi-count informations can be considered, and the Supreme Court of Canada can weigh in on the issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.